when you're starting out, have that founders agreement in place.
Yeah.
Then it can sort of set the basis of what's going to happen next. What's
Right.
going to happen next is that you need to go to CIPC from day one and register a PTY Ltd. No, you don't actually have to. Then you need NDAs. So those are non-disclosure agreements.
Okay.
So if you put those in place, then it binds the people that you're going to be disclosing certain confidential information to.
Hello and welcome to another episode of the Legal Standpoint podcast, where we explore the legal aspects of starting and running a business venture in South Africa, one conversation at a time. If you are a startup founder, a business owner, or a freelancer trying to navigate the complexities of contracts, compliance, or intellectual property, welcome, you're in the right place. I'm your host, Kitumeti Pule, the co-founder of Legal Standpoint, and I'm so glad you chose to be with us today. Today we're sitting down with Buntu Pato, an admitted and practicing attorney who has worked with startups, SMEs, and growing ventures, helping them navigate a plethora of legal matters, including Legal Standpoint. He is at the heart of legal practice with experience spanning 10 years, which means that he's seen a lot and he can share a lot as well. In today's episode, we will unpack legal mistakes that founders tend to make in starting their businesses and growing their businesses. We will unpack how to protect your business from day one. And we'll also learn about, real stories from the trenches that every founder should hear. So welcome to the studio, Buntu. Thanks for joining us.
Welcome, Buntu. Welcome, Gitu.
Yeah.
Thank you for having me.
Yeah.
It's a pleasure.
Yeah, it's always a pleasure. We've known you at Legal Standpoint for a few years now, and you've been, a really instrumental partner from us from our early days. So, it's always great having a conversation with you. And, the whole purpose of today's conversation is just to share, just common pitfalls that you've seen in your experience as an attorney when working with founders, and just common mistakes that founders make, and also, considerations that they should prioritize from day one. We're just going to get straight into it because we want to, understand as much as we can in the short space that we have with you, or the short time that we have with you. I think the first thing is, you've been in the space for 10 years now, which is quite a while, and you've worked with... Who's counting? They're 10 years and 2 months. But, you've worked with a lot of startups, you've worked with a lot of SMEs. I'm curious to understand what some of the most common mistakes that you've seen that they make when navigating, growing their businesses.
Okay. Where do I begin? Okay. So the thing with startups is that, it's an idea between you and your friends or your varsity colleagues. It starts normally in a garage, in a South African context, in the dorms.
Yeah.
You come up with this idea. It's you and your friends or your classmates. You've known each other since first year. And then you start getting into it. Now, the first mistake you've done there is that you've agreed to start a business with people, but you have not put it in writing. And so that's the first mistake, is that the founders do not necessarily set down what the expectations are from each other.
Right.
As you would understand that when you're starting a business, business needs capital, it needs people that are going to do the actual work. It needs sales and marketing and all of those other things that go into or that tie into together.
Yeah.
So founders start doing the work without ever having to be clear of what is expected from each other.
Yeah.
So that's common pitfall number one, because after 4 years, I've gotten a bursary to go and study overseas. Now I'm no longer interested in the business.
Yeah.
So then the arguments start happening. Okay, I'm leaving. What's going to happen to my share of the business? Hey, but we've never even spoke about shareholding or things like that. So I think the major one is not putting the founders agreement in place from day one, and then everything else then follows after that.
Yeah. And then do you think that's something that you've seen a lot as well, where people will just have legal, or not legal, verbal agreements, and just have conversations but never have anything written down? Is that a common thing in the space?
Do you call it common if it happens every day?
Yeah. Okay. Yeah.
Look, it seems like it's a norm.
Right.
Look, there's nothing wrong with a verbal agreement. It's valid, it's enforceable. However, the issue comes when people don't remember what they agreed on.
Hey, and people forget a lot.
Yeah, people forget a lot.
Right.
So to create that certainty that contracts create or written contracts create, it's better to just put it in writing.
Right.
From day one. So then that 4 years down the line, when you've forgotten,
Right.
it's easy to kind of remind you to say, no, but you agreed.
Right.
Yeah, it is.
Okay.
So that's the issue with oral agreements. But there's, gentleman's agreement. It's something that's recognized in South Africa.
Okay, so verbal agreements are enforceable, but people tend to forget. So just, to be on the safer side, it's always important to have it written if you're going to have an agreement with your co-founders or any other stakeholders.
Yeah.
Okay, awesome. And if you were to create a legal starter pack for someone starting a business today, what would it include exactly?
Okay. I think what we need to dissect is starting a business, right?
Yeah.
Because sometimes when you sitting around in the dorms with your friends, right, you've got this idea.
Yeah.
You don't know whether it's going to be a business or not.
Right.
So, but you know that, okay, we can create this product. Are we going to sell it or not? What's going to happen? So during that conversation, that's when then I say the founders agreement needs to be set up, right? And then I think another common misconception is that you need to go to CIPC from day one and register a PTY LTD. No, you don't actually have to, especially if you don't know what you guys are conceptualizing is going to become a business or not.
Right.
So that's where then the the founders agreement is going to kind of regulate the relationship between you guys as the founders.
Yeah.
And then as soon as then now you've you've spoken about how you're going to monetize it, what the product is going to be, then now you're talking business. You're no longer talking concept.
Right.
Then you go to the CIPC. So now when you go to the CIPC, because we've got a functioning CIPC,
right?
They give you all of these templates. It codes company law, it codes all of these relevant legislation, but I'm trying to now to be in the shoes of a founder who hasn't even passed contract law.
Right.
Yeah, so that is going to be foreign language to them.
Right.
So I think if you're talking startup pack, you need to have a simplified MOI.
Okay. What's an MOI?
Memorandum of Incorporation.
Okay.
Okay.
No, because we need to remove the jargon, right? For all the founders that are listening.
I get you. Okay.
Yeah.
Okay. For going forward, no more jargon.
Okay. Yeah.
So you need to have a memorandum of incorporation that I think is simplified, that you can understand with your co-founders, right?
Okay.
And then that document, as much as the CIPC has a standard one, I think as part of the startup pack, you need to create your own.
Right.
And I say this because if you do not understand the sections that are referred to in the standard MOI that the CIPC provides, then you're going to commit certain pitfalls that are going to be a problem when you, for example, have to go fundraising and all of these other things.
Yeah.
Fortunately enough, an MOI can be amended.
Thank
But
God.
it's better to get it right the first time.
Right.
And then after that, I think I've already mentioned a founder's agreement. So that could be the first document. Then that could be replaced by a shareholders agreement as soon as then you and the founders have decided that we're going to open a company. It's going to trade as a PTY LTD.
Yeah.
PTY LTD meaning a private company.
Okay.
Because there's different types of companies in South Africa. So the private company would be the PTY LTD.
Right.
Also, I don't want to say, PTY LTD is the automatic, structure that founders must go for. I mean, you can trade as a sole proprietor.
Yeah.
But there's certain risk that come with that. So
that's when you're trading as you're the business, the individual is the business.
As the individual, yeah. So there's certain risks that come with that.
Yeah.
So you want to separate then your business from the individual. So then hence we always advise founders to incorporate.
Right.
So I think also another one, if you're going to be now, you and your friends have conceptualized the idea. You've decided that it's going to be a business. You've drafted your business plan.
Yeah.
Now it's time for you to raise funding. And if then you're going to be raising funding, then that means you need to let third parties into your business, so they're going to
Right.
know what you guys are creating.
Right.
Then you need NDAs. So those are non-disclosure agreements.
Okay.
So if you put those in place, then it binds the people that you're going to be disclosing certain confidential information to keep it confidential, and then they can only release it under certain circumstances.
Yeah.
So that's very crucial
Yeah.
because you don't want today to pitch to someone your
Yeah.
concept or your product. The following day you see it
Ish.
on the shelves.
Yeah.
I think
Right.
also another one would be dealing with IP from the beginning. So what I mean by IP is intellectual property. So intellectual
Right.
property, it's what your mind creates. So if you guys are creating an app, so the coding that goes in there,
The source code. Yeah.
yeah, the source code that goes in there, that would be protected by IP, copyright specifically. If you guys are creating, a new design for a chair that is going to be
Yeah.
economically fit, then you need to, trademark the designs, register the designs, etc., etc. It gets a bit
Right.
complex, and I don't
Right.
want to complicate it. But there's numerous attorneys that specialize in IP. So
Right.
in terms of that, but I think at the beginning, if you're still talking starter pack, a simple assignment session agreement could go a long way, because then whoever is creating whatever product that will be protected by intellectual property, then they need to cede it to the company, or assign it to the company, and then it will, then there would be that transfer of ownership.
Right.
Yeah. So let me count them back. Founders agreement before you incorporate, shareholders agreement when you incorporate, memorandum of incorporation, and then the NDA, and then the transfer of IP documents. I think also, considering then that you're gonna be incorporating, you're going to hire people, contractors, to come and provide a service to your business. So you need to have those SLAs. What I mean by SLAs are service level agreements with your contractors. If you're going to have employees, you need to have employment contracts
Right.
in place with your employees. So
Yeah.
I think there's 7 documents that I've counted.
This
now.
is a very big starter pack, okay? That's what we're seeing here. And I mean, it's like really important documents that you need to have, right? So thank you for like breaking them down and being so comprehensive. And if you're a founder, like don't be overwhelmed. I think this is maybe like actually a great starting point for this conversation, because if you try to DIY all of that, it gets complex, it gets overwhelming. And it's always great to just get like a lawyer on board. So yeah, thank you for that starter pack. Like it's pretty comprehensive, but like
But
really
it comes
valuable.
at different stages, though.
Different. So yeah, it's
different
like gradual.
stages. So yeah,
right.
it's gradual. So perhaps let me put it this way: the
Yeah.
advice that I can give is that you need to, when you're starting out, have that founders agreement in place.
Yeah.
Then it can sort of set the basis of what's going to happen next, what's
Right.
going to happen next, and then everything else can follow. So
Yeah.
yeah.
Okay. So founders agreement. That would be like the start, the first start.
That's the agreement that you need to sign whilst you're in the dorms.
Right. Okay. Okay. Awesome. Yeah. And then, like the conversations that I've had with different founders, the one thing that keeps coming up is that, there's this widely held perception that lawyers are really expensive, which is why people then tend to DIY and like do their own thing. They go on ChatGPT now, or, like try and find like templates online, or just like other mechanisms where they're just doing it themselves and trying to spare whatever cost they can. Can you just chat us through like the dangers of trying to go that direction, and like when exactly founders should engage lawyers in their journey.
Okay.
Yeah.
Where is this myth coming from?
No,
That attorneys are expensive.
I mean, some of them are. Some of them also. I mean, I understand it, right? But literally, all the conversations I have, they're like, no, like we just don't have the
a
funds
myth.
for it.
It's
Is
a
it?
myth. It's a myth. I'm
Bust the
telling
myth for us then. Yeah.
Okay. Attorneys are professionals, right? So
Yeah.
they charge a fee for the service that they provide.
Mm.
But the myth is incorrect because you go to your lawyer or an
Yeah.
attorney, right? Doesn't have to, if it's the first time, it's fine.
Yeah.
You go to your attorney, you present your problem. Then the attorney is going to respond saying, this is how I believe the problem is going to be solved.
Yeah.
And these are the costs that are associated with me solving that problem, right?
Right.
You've only went to one.
Right.
Why don't you go to the second one if you think that one is expensive?
Right.
So, and also there's numerous ways in which you and the attorney can do business.
Yeah.
There's contingency fees.
Okay.
That's when if we win, then I get a certain percentage of
Right.
the win.
Okay.
Yeah, it's contingent on us winning.
Right. Right.
Yeah, but it's a
Yeah.
risk that the attorney, takes because they look at your case
Yeah.
and then they decide, okay, I think the merits are good here.
Yeah.
There's a high chance that we can win, and then you enter into the contingency fee agreement with your attorney.
Mm-hmm.
There's also, other avenues. You can have a retainer
Okay.
with your attorney, and
Right.
whatever retainer that you agree on, it could escalate depending on whatever that you guys want to make a condition.
Yeah.
Then there's also hourly rates that attorneys charge. So
Yeah.
the field is not complex. You
Right.
just need to go to an attorney.
Right.
Then, if you're not happy with what the attorney is telling you, go to another one.
Right. Okay.
So now that we've busted that myth,
Right.
right?
Yeah.
What was your second question again?
Is like when exactly should founders
Okay, yes,
engage
okay,
a lawyer? Yeah.
Yeah. So from the beginning,
From day one.
maybe two.
Or even day zero. Okay.
Let's say day two.
Okay, yeah.
From the beginning.
Yeah.
And I say this because as much as you can, create your own founders agreement, but there may be certain things that you can overlook, thinking that, it's not going to be a problem today, or you just didn't think about it.
Right.
So when you then go to an attorney, then an attorney would, think about all the possible scenarios that might happen, and then what happens then when those scenarios come alive,
Yeah.
and put mitigating, circumstances of how to mitigate whatever that could happen in the future. So hence I say from day one. But now tying it back to what I've said previously about you agreeing with your attorney on
Yeah.
how the fees are going to work. I mean, when you starting out, right, the retainer,
Yeah.
because remember the attorney is the advisor. They're not there on the day-to-day
Right. Like
operations of the
Yeah.
business. So let's say, for example, now you've conceptualized your idea, you've done your business plan, and
Yeah.
you've decided, you know what, actually, I think
There's something here,
let's incorporate, let's create a company.
Right.
Now, that's 2 months down the line. You go to your attorney and you're like, we're thinking of incorporating. How can you assist us?
Right.
The attorney will then provide you with a solution. But if, for example, now you are going to have fundraising rounds, there's going to be a lot of third parties that are coming into the business, then
Yeah.
it means then that the work is going to be a little bit more. But when you guys have decided to incorporate, I think the work is not going to be as much as when
Right.
you are negotiating a deal.
Right.
So it's flexible.
Okay.
The myth must be busted today.
Right. Of course, the lawyer is going to come on here and tell us that it's not expensive, right?
Yeah.
But thank you for busting that myth. And, I think the way you're explaining it, it's like law is a business, right? And I think like a law firm is also a business. So I think for the founders listening, it's really like the same principles where, before you commit to like a certain supplier, like you'll shop around and like compare costs and compare like the different rates and find one that you're comfortable with.
Exactly.
And that's exactly what you're saying. Like if the one lawyer you've gone to seems a little bit pricey, like go to the second one and go to the third until you find someone that you're comfortable with. But even then, like it doesn't have to be 10,000 rands up front. Like it can be, broken down and these different formats of like paying the lawyer.
Yeah.
So, okay, cool. I think, hopefully now there's more people who are like willing to engage lawyers. So thank you for busting that myth. And I think I want us to like swiftly shift over to like complex contracts and compliance now, because I think that's another thing that kind of makes entrepreneurs nervous. They're constantly having to deal with contracts, whether it's with suppliers, with employees, with founders, as you mentioned, with investors, hopefully if, you get to raise funding at some point. For people that think maybe like contracts are not that important, in your business, because I think like again, some of the other conversations I've had, people think it's customer acquisition that's the most important, and like marketing and brand visibility, and like the legalities tend to, fall down on the list of priorities. So are you able to just briefly speak through why exactly having like legally sound contracts is important from the onset in your business?
Okay. I've heard a certain gentleman
Yeah.
telling me one time that compliance is expensive, right? But non-compliance is even more expensive.
Right.
So, I've taken what he said and I've tried to even implement it even in my business.
Yeah.
There's quite a lot of compliance, and I don't want to call them issues, but a lot of compliance challenges, for lack of a better word, that small businesses, founders have to comply with, or they have to jump through. So, but if you decide to ignore it, SARS is going to come in and knock on your door, and you're going to be faced with a fine,
Right.
whether it's SARS, whether it's FIC, whether it's, there's a lot of, depending on what sector you're in.
Right.
So
Different regulators,
Yeah, there's a lot of different regulators. So, and
Yeah.
when now you don't comply with what the regulators say, they're going to fine you. And if now you find, so had you invested 10,000 Rand before the problem came about, you trying to comply, then you wouldn't have been found wanting and had to pay the fine.
Right.
So that's the simplest way of putting it. Non-compliance is more expensive than compliance.
Right.
So to protect your business, it's always better to just ensure that you're compliant from the get-go.
From the beginning, yeah. And I think that's a recurring theme, like in the legal space as well, that the cost of being reactive is a lot higher than being proactive and having those like legalities figured out in the beginning, right? And I think like that's really like the purpose of this conversation, just to drive home that point that even if it doesn't seem like I know it's like unglamorous and like the unsexy part of like building a business, having to deal with legals and like like accounting and all of that, but at the end of the day, like those are really the fundamentals, and if you don't have them in place, like you jeopardize the entire business, right? So what's the point then of investing in like the marketing and sales and customer acquisition if all of that can be stripped away because of you not being compliant and your legals not being sorted. So thank you for like driving home that point.
Yeah, and I think a message that I can pass on to the founders is that, remember at the beginning of our conversation, I said the legal person is the advisor. To the business. They're not there when you are designing the marketing, branding, and all of those things. But because now they're an advisor, it's always a telephone call here once a month. We're thinking of publishing this marketing material. Because remember, there you could do a beautiful design, but you're infringing on someone else's IP. So that's why you just have to. that telephone call with your attorney, okay, no, this is fine. It's stock imaging. It's fine. It's you're not infringing on anyone's
Yeah.
IP. If it's you're thinking of, bringing in someone into the business who's going to be, let's say, running your admin.
Yeah.
Is that an independent contractor? Is that an
Right.
employee? Those are the conversations that you can have with your advisor once a month. It doesn't have to be, we're going to lawyers, we're going to be paying R1 million. No.
Right.
It doesn't work like that.
Right.
And that 1 hour conversation a month is way cheaper than you bringing in someone that you didn't intend for them to be an employee.
Right.
You intended for them to be an independent contractor. And then down the line, you have to pay UIF for this person.
Right.
All of the...
They take you to the CCMA.
They take you to the CCMA.
Right.
And so that's the message that I'm trying to drive, is that have an advisor, just like you would have if you, an app developer, you, a junior engineer, you're going to have a senior engineer that that's going to be your advisor.
Right.
Is this the correct language I'm using, etc., etc.
Right.
So same thing with legal.
Right.
Same thing with legal.
Yeah. Okay. Buntu is on a mission to dispel some myths today. I can see that. Okay, awesome. And when we're still on the topic of contracts, right? Are there any red flags that you think founders should always keep a lookout for when reviewing contracts?
There's plenty.
Okay. Yeah. Let's say top 3.
Okay. Top 3. Okay. I'm going to use the example again of a tech founder.
Yeah.
Right. So you've designed your product. It's ready to go out into the market.
Yeah.
And there's a investor from Silicon Valley that likes your product.
Right.
And they want to come in as an investor. Right. But you meet the investor in Cape Town. You talk, you conclude the deal.
Yeah.
Because now you thought, I don't need to have a legal advisor. You're relying on their legal advisors.
Right.
And their legal advisors are in the US. So the contract that you're going to be sent is obviously going to say, should there ever be a disagreement between the parties, the courts of California are going to have jurisdiction.
Yeah.
The deal was concluded in South Africa. So why are you, solving your problems in the US? It's going to be way more expensive even for you. So that's red flag number 1. Whenever you're dealing with an international person, just always ensure that, if the deal is a South African deal, everything must be done
in South Africa.
In South Africa.
Right.
Number 2, exit clauses. Exit clauses. You don't want to, I can't imagine any contract without an exit clause.
Right.
You want to, if things are not working out,
there must be a clear way out.
There must be a clear way out.
Right, yeah.
There must be a clear way out.
Yeah.
So always have a termination clause in your contract.
Okay.
I think the third one would be assumptions.
Okay.
Assumptions.
That's
Don't
a big
assume.
one.
Yeah. Don't assume.
Right.
If it's not in writing, then you're inviting a lot of misinterpretations.
Right.
So do not assume. And I understand that, when you're talking with founders, founders are going to say, he knows.
Right.
He's my boy.
Right. He's my boy. Yeah. Yeah.
Yeah, he knows. Yeah. He knows I don't have money to pay him.
Right.
Yeah, but
does he really know? Yeah. Yeah.
Yeah.
Okay.
So I think those are my top 3.
And I think that last one is actually so relevant because there are so many things. And this is exactly why you need to be talking to a lawyer, because you don't know what you don't know, right? And I think even for us at Legal Standpoint, we've had conversations with you where you've brought up so many other aspects that we hadn't considered before. And it's okay, you really don't know what you don't know, and you need someone who's a domain expert to come in and tell you where the dangers are and where the red flags are. And I guess we should just not assume that the other stakeholders know that we're on the same wavelength about things. So clearly that's not the case. We're all thinking our own things and making our own assumptions. So thank you for that. Very relevant. And then without revealing any identifying information, Because I know, like with lawyers, you have client
Confidentiality.
confidentiality. But have you ever had to rescue a client from a bad contract? And yeah, just without revealing any like confidential information, like what was the situation, and one that's maybe applicable to founders generally.
Okay.
Yeah.
I think, I don't want to call it rescuing. Don't want to call it rescuing because
Okay.
I'd be taking the credit.
Oh, okay. Yeah. You want to take the credit? Yeah.
But I think the law requires credit, not me.
Yeah. Okay.
The reason why I say so is because we've had a situation where the parties entered into a contract, right?
Okay.
But according to now the supplier, this is what you owe me.
Okay.
But according to the other person, they're like, hey, but I didn't think this is what I owed you. And then when you then consult with the client,
Yeah.
you find out that, no, actually, there's no contract here.
Oh, okay. Yeah.
Yeah, because remember,
Okay.
contract has those 5 elements that need to be met, right?
Yes.
Now, with there being consensus, right, there needs to be an offer and an acceptance of that offer that is unconditional, right?
Yeah.
So when then ours or the client now was making the offer, it was not accepted per se, but there was a counter offer.
Okay.
Yeah.
Yeah.
So if then there's a counter offer, then can we then say there's ever a meeting of minds? There's never a meeting of minds. I thought I was giving you an offer, and,
Right.
I thought you had accepted it, but
Right.
based now on what we've written down, it was actually never an acceptance,
Right.
but you've made a counter offer.
Right.
So that's why then now there's a dispute.
Right.
You're thinking that the person owes you
Right.
this amount.
Yeah.
Because when they were making the offer to you, they said, for example, I'm going to buy, or please sell me your car for 100,000, right? And then instead of you saying, I accept, you say, no, look, this car has what do you call the nice max? BBS max.
Okay.
So now it's not 100,000, it's 120,000.
Okay.
So the deal still happens. I take your car and I pay you the 100,000, but you come back and say, no, but
you still owe me the
you still
20K.
owe me the 20.
Right.
Yeah. So
Yeah.
that's the situation that happened. So because there was never an offer and acceptance, then
Yeah.
it means the parties, there was never the meeting of minds in order for a valid and enforceable contract to happen.
Right.
So then it means the contract is void from the beginning.
Right.
Yeah.
Okay. Well, hopefully that doesn't happen to the people listening today. Hopefully they, manage to avoid that situation. And I guess like it goes back to what you were saying before about like assumptions, right? And how in this case it sounds like there was like an assumption about what the agreement was, but there actually wasn't, because both of them had different interpretations of what the end amount would be. So yeah, like make sure it's written down and you have like you're on the same page about what the deliverables are. Okay, awesome. And then I think like now I'd really just like to shift gears again and just focus on some of the real life lessons that founders can learn, or some of the things that you've seen in your years of practice, where founders had to learn the hard way. And I'm curious if there's ever been like an issue where there was a seemingly like small legal oversight in a contract that then snowballed into something bigger. Yeah.
It's the example that I was making about
Yeah.
with the foreign investor, and then now
Yes.
there's a dispute. So, a relationship always starts in the honeymoon phase,
Right.
whether be it contract or be it relationship.
Right, right.
Yeah. So the honeymoon phase ended, and now the dispute started coming up.
Yeah.
And now, obviously, the person there now, when they were signing the contract, they thought, this is my
Yeah.
person. Let me
Right.
just sign. now that the disputes are starting to come up, then they go back to revisit the contract.
Yeah.
And then when they start looking at the contract, they see, now I can't even go to a South African court. I've bound myself and my company to resolving this dispute in the USA. Where do I even begin?
Right.
How much is it going to
That
cost
sounds
me?
like a nightmare. Oh my gosh.
It's a nightmare
Yeah.
because at the end of the day, we need to respect the sanctity of a contract.
Right.
It's binding.
Right.
So if you've agreed, you have to comply.
Yeah.
So that was one
Yeah.
small situation that a person overlooked, but ended up being a headache. And when now you're faced with a
Yeah.
situation of having to go to another country in order to resolve a dispute.
Right.
Sometimes you just give up.
Right.
Yeah. So I think.
Oh, shame.
Yeah.
Yeah.
So it's in order now to protect founders in this situation. South Africa, we're a country that believes in Ubuntu.
Right.
So
Right.
mediation, put it in there.
Okay. In the
As-
contract.
Yeah, as ways
First
to
step,
as
yeah.
a first step to
Yeah.
to resolve a dispute.
Yeah.
Get an independent mediator.
Yeah.
Speaks to the two of you guys. Try and knock some sense into you guys, and then who knows?
Yeah.
You could save so much money that you're
Right.
gonna use litigating a matter that could have just been solved by having an
Right.
honest conversation between two parties,
Right.
and then they come out of that mediation with an agreement. So
Right.
I support mediation.
Yeah.
Put it in there.
Right.
Also, another thing is that in Gauteng alone, there's only two high courts, right? Pretoria and Joburg.
Yeah.
So you can imagine how many people are in Gauteng.
Right.
So the dates for civil trials,
Yeah.
think
It's
I-
lengthy, right?
I think we're sitting at 2027 now.
No, stop.
Yeah, it's bad.
Oh my gosh. Okay.
So
Sounds like a business opportunity there as well, but okay. Yeah. Yeah. Okay.
So people want to solve problems and they
Yeah.
want to solve them now. So mediation is there.
Okay. And I mean, I know like mediators are different from like lawyers, right? It's two different entities. But have you found yourself in a situation where you've had to mediate, like let's say between co-founders?
Yeah, all the time.
All the time? Yeah.
All the time.
Yeah.
So, but it's better for the mediator to be an independent person, because if I'm hired, for example, by legal standpoint,
Yeah.
then obviously in the mediation, I'm going to be pushing your agenda as my client.
You're right.
So hence, then it's always advisable to look for an independent mediator.
Yeah.
It could be anyone. Yeah.
Okay.
It could be anyone.
Yeah.
Reverends mediate marriages.
Oh, okay. Okay, yeah, well, yeah, for the marriage, like what you were saying, reference are like mediating for business as well.
Yeah.
Yeah.
So
Okay.
it could be anyone.
Yeah.
I think the major things to look out for is it a person with a sober mind?
Okay.
Yeah.
Sober mind. Okay. So let's put mediation clauses in our contracts, because I think you're right. Like when you're starting a business, there's so much excitement, right? About what we're building and, like how we're going to take over the world, and like all these ambitions take over. And we don't really think much about when things go left, right? And when we like have disagreements, which I think it's good to like talk about these like very uncomfortable things right at the onset. But in the case that things do go south, like have a mediation clause in there and try use that as like the first step of resolving the matter.
Because,
Yeah.
especially in a relationship where the other party has leverage, so it would be a fight of David and Goliath.
Right.
If the other person, has millions in the bank and
Right.
they're saying, well, we're taking you to court, but
Right.
have you tried mediation?
Right. Okay, awesome. And is there such a thing as a founder coming to you too late? Like are there situations where you've encountered where like the person came to you a little bit, later than they should have, and the situation is now, I don't want to say like unsolvable, but it's the timing is a little bit off. Like are there situations where that happens?
Yeah.
Yeah.
Look, in many contracts, there are time bars.
Yeah.
So, for example, if you don't do something by a particular time, then it lapses.
Yeah.
Um, yeah. So there's many situations where that can happen.
Yeah.
It happens a lot in also for me going back to offer and acceptance.
Yeah.
So if I make an offer to you, right, and I say you have to accept it by Friday,
Yeah.
this Friday, and then you accept it by Monday, but there's no offer to accept.
Right.
The contract has
Right.
lapsed,
It's
or the
expired.
offer,
Yeah.
the offer has expired.
Right.
So there's no offer to accept.
Right.
So that's a situation of someone coming,
Too
too
late.
late. I'm thinking,
Yeah.
but I've already bought the whatever that was needed to supply, but you didn't accept it
Right.
when you had the time.
Yeah.
So there's many situations that arise like that where time bars are in place and the person does not stick to the time bar. But
Okay.
like I say, in law,
Yeah.
there's almost all the time a solution to every problem.
Right. Okay. There's always a solution to a problem. Okay, awesome. And then just, as the final question, I can't believe like the time has actually just flown by. But this is my last question, right? For all the startup founders, the business owners, the freelancers, that are listening to this conversation, if you could like share one legal advice, right, that they should all like adhere to or like try, really like take seriously across the different businesses and industries, like what would it be? Like what's the one legal consideration that all of us should make when starting a business?
Do not assume.
Okay.
Do not assume.
Yeah.
Okay, maybe it's going to be more than one.
Okay. Yeah. Okay, that's fine. Yeah.
Okay. Do not assume.
Yeah.
Always have your legal advisor
Yeah.
around since from day one.
Yeah.
It will help solve a lot of future problems that your company may face. And lawyers are not expensive.
Okay. Right. Still busting this myth of like lawyers being inexpensive. But yeah, Buntu, thank you so much for joining us. This has been a really like practical conversation, I think, more than anything. Very insightful. I think, for the founders that are listening, like I was saying earlier, like it really seems like something that's not top priority or top of mind when you're starting out, but it's something that should be, right? And I think you've done a really brilliant job of, explaining why certain things are important. And I think if you're someone who's building a business that, you take seriously and you want it to like, outlive you and, grow into something that will live in the world and like create impact, you need to have those legal safeguards in place, right? Whether that's protecting your IP, whether that's actually protecting the business's interest and the contracts that you have with the different stakeholders, whether that's even if you get to like a point where you get investments, which I mean, it doesn't happen to like everyone, but if you do have the opportunity to get someone to invest in your business, like there's so many legalities involved with that. And I think, yeah, you've done a really like great job of explaining with no jargon, what we should be considering. So thank you so much for coming on.
Thank you for having me.
Yeah. Okay, awesome. So that's been another episode of the Legal Standpoint podcast. Thank you for tuning back in. If you haven't seen any of our other episodes, please go back and check other conversations that we've had that are relevant from a founder's perspective. Please just check those out. Don't forget to like and subscribe to this episode. And if you need legal help with anything, you can chat to Buntu. He's been a really instrumental partner for us. But you can also check out Legal Standpoint because we understand the complexities and how overwhelming it can be navigating, the world of law as a founder. So, just check us out as well, and then we can help you out with that. Thank you for tuning back in, and we'll see you next time.